Good morning, council.
Morning.
Morning, Judge.
Welcome back to the 95th District Court. Looks to me like we have as many as 4 different motions today. Am I, Mr. Cheek?
I believe there's just 3: the motion to sever, the motion to reconsider, and then plaintiff's motion for sanctions.
And then I haven't issued a ruling yet on your client's motion for sanctions, so that'd be the 4.
That's right, Your Honor.
All right.
Correct.
Ms. Rouse, are you ready?
Yes, sir.
Okay, this is DC 20-07799, Drenisha Scott versus J&K Real Estate Investments Limited, et al. On both sides of the docket. Obviously, we're doing this hearing again over Zoom, and therefore it appears to carry an air of informality. However, this is a formal proceeding of the 95th District Court. For the record, the courthouse is open, the courtroom is open, but in addition, I'm broadcasting this over the court's YouTube channel so the public has full access to this proceeding. However, I have to remind the parties that there is to be no recording of any proceeding. There is one record and one record only that comes out of proceedings in the 95th District Court, and that is the record maintained by the official court reporter of the 95th, Ms. Rouse, who is here, who is present, and who will report this proceeding. Any questions about either of those things?
No, Your Honor.
Mr. Sung or Mr. Kelly, which of you intends to take the lead on behalf of plaintiff?
That would be me, Your Honor.
All right, care to introduce yourself, your co-counsel, and who you represent?
All right, James Sung for plaintiffs, and I also have Mr. Kevin Kelly and Ms. Patricia Morgan for plaintiffs as well.
Welcome all of you to the 95th District Court. Mr. Cheek?
Heath Cheek with Bell Nunley representing the defendants. I also have with me Ms. Subba Syed and Mr. Mason Jones of my firm.
Very good, and welcome you too also to the 95th District Court. I have read all of what's been presented. Mr. Sung, I'm going to make an observation before we begin, but then I'm going to let you present your motions. We're going to take up the severance last. It is my very strong opinion that plaintiffs should consider withdrawing the Section C to plaintiff supplemental response to individual defendants' motion for sanctions filed December 28. Your Section C, number 1, misstates the court's view of the evidence, assumes this is an evidentiary fight, not a legal fight over duty, which the Del Lago case that you have cited expressly makes a point of. Duty is a legal decision, not a factual decision. And frankly, the threat in Section C that if I don't rule the way you want me to rule, that a claim will be brought before the Commission on Judicial Conduct is unbecoming of any advocate in any court in this country. And I strongly urge you to consider withdrawing Section C to that document. That said, which would you prefer to present first, your motion for reconsideration or your motion for sanctions?
Reconsideration, Your Honor.
All right, please proceed.
Yeah. Your Honor, we respectfully move and ask this court to reconsider the granting of summary judgment as to Greg James. Greg James had a legal duty to Tommy Rogers to keep the club free of known altercations physical escalations, and dangers at the event that he himself organized, advertised, and promoted for. He owed a duty to keep minor plaintiffs safe, especially since he both wanted and he received compensation for an event he personally promoted, marketed, advertised, and organized. He opened himself up to personal liability as a result. It's not the minor plaintiffs or the plaintiff's fault that he failed to organize his marketing business in a business entity to protect himself. Plaintiffs should not bear the burden that, especially the minor plaintiffs, of their father's death when Greg James's negligence and greed in putting profits over safety caused their father's death. Your Honor, Del Lago controls here, and as Your Honor pointed out, duty is a question for the court. However, the degree of control as to Greg James's control over the premises is a question of fact. Del Lago's holding that the nature and character of a premises can be a factor that makes criminal activity more foreseeable, and the criminal misconduct can be foreseeable due to immediately preceding conduct. The situation in Del Lago is analogous to the situation we have here, Your Honor. Just like in Del Lago, where the hotel staff had actual knowledge of it, that a violent brawl and a physical altercation was imminent and stood by and did nothing, Greg James did absolutely nothing to prevent the continued escalation of violent behavior from patrons on the premises, one of them being the alleged shooter, Franklin Moore. A question of fact exists to Greg James's degree of control over his premises, over the premises of one set of his promoted event set Sunday. There's evidence in the record that the promotional team, including Greg James, would provide an extra layer of security and would contribute to the security and safety of their promoted events. His own answers in written discovery point to the fact that he himself would de-escalate situations on a case-to-case basis and notify authorities. He was present bartender.
I'm sorry.
His own mission, denying question.
So, you broke up, unfortunately. You paused and then you broke up.
I broke up? Oh, okay. I think I was referencing, okay. Greg James's own written discovery points to the fact that he was a bartender present at the night in question, that he himself de-escalated situations on a case-by-case notice and would notify authorities of that. It's the role of security to de-escalate altercations at one set, and that's precisely what Greg James participated in. And there's evidence that he exercised a degree of control over the premises. Your Honor, we would ask this court to, Your Honor, we would ask this court to reconsider the granting of summary judgment on that.
I understand your argument, but I got to probe with you the analogy of Del Lago. What is the very first sentence of the Supreme Court's opinion?
That it is a very narrow holding.
No, it says, this appeal concerns a bar owner's liability for injuries. Is there any evidence that Mr. James was a bar owner?
No, Your Honor.
Is there any indication that the Supreme Court gave, and I'm open to looking at it. I thank you for citing Del Lago as the basis for this motion to reconsider, because you caused me to go back and reread every word of the opinion. Is there anything in Del Lago that you can point to that says someone who is not an owner of the premises has those premises liabilities that arise out of potential foreseeable criminal activity?
Your Honor, Greg James may not have been an owner of the premises, but he was a possessor of the premises. He promoted, advertised, and marketed, invited patrons to come to one set where he himself was physically present. He had a degree of control as a host, as a promoter, as an organizer of said event. And his control opens him up to liability. Okay.
Best argument you've made on this point. I don't agree, but that's the best argument you've made on this point. Mr. Sheik, any response?
if I say no, Your Honor, you've hit it right on the head. Del Lago requires possession of the premises. Del Lago is not some new law. It is tagging on to Timberwalk and saying, we agree with Timberwalk, but on the foreseeability factor, you can relax it if there's this 90 minutes of violent behavior preceding the accident, which is what happened in the incident in Del Lago, where there was a wedding party and a Sigma Chi fraternity getting in 90 minutes worth of arguments with each other that preceded it. That's just not the situation here at all. Mr. James was a promoter. He has no possession of the premises. He's not on the lease. He's not mentioned on the lease. He was not assigned the lease. He was not given any degree of control over the premises. The security person that Mr. Sung references was supposed to be a doorman to check the guest list, not somebody who would have been on the patio that would have controlled the situation, or would have been a primary person to call police, as they have suggested. There's just no evidence of control whatsoever that they have put into the record. They had 6 months to get that evidence, and they have none. Because they don't have any because there is none. Mr. James's role was pretty limited here. He put up some Facebook posts and passed out some flyers, got some people there, and he maybe worked as a bartender that night. But none of that creates control or possession of the premises.
That's my read of the case law. Mr. Sung, I'm specifically looking at pages 767 and 768 of Del Lago, and where they start off by saying, we have not held and are not holding here. We have not held and are not holding here. They say that 3 times basically, and then say, generally, even a premises owner has no duty to protect invitees from criminal acts. And then they go on and discuss the Timberwalk factors. You've got the defendant in this case who, by all accounts, is the owner of the premises. But Mr. James isn't one of them, and I've already granted the summary judgment. I'm not going to reconsider the summary judgment as to Mr. James. All right, next, you can present your motion for sanctions. I've read it and I've read the response. I don't think you stated a cognizable cause of action for sanctions against defense counsel, but I'm willing to hear it if you'd like to proceed. For what it's worth, and for what it's worth, Mr. Cheek, I'm going to tell you up front, I'm not inclined. I wasn't inclined when we heard this 2 weeks ago. I told you I'd issue a ruling Monday, and then I see all these the following Monday, and then I see all these incoming motions. I knew we were going to get together. I do like one line that was in the response. Lawyer's got a lawyer, and I've given the plaintiff leeway to lawyer, and I'm not inclined to sanction them for that. Although I do think that section C to the response should be withdrawn. Yes, Mr. Kelly, you're muted. You're still muted, Mr. Kelly.
There.
Sorry about that, Your Honor. The host had to unmute me. I've been married for 17 years, so I'm used to being muted, Your Honor.
Fair enough.
With that said, Judge, we will withdraw our motion for sanctions at this point. Hopefully it doesn't have to come up at another point, but we do want to make things easier for the court to consider. And we will also withdraw from consideration the provision that the court has issue with as well, so that we can take that off the table.
Okay. Very good. So the motion for sanctions is withdrawn. Mr. Cheek, I'm going to deny defendant's motion for sanctions. I expressed my concerns about that Facebook message, and I still have them, but my theory is they brought the case. You got your motion for summary judgment heard. You got them timely heard. If this were a 91A, I'd probably be compelled to order sanctions, but I've got discretion because it's not a 91A. So I'm not inclined to order sanctions against either party at this time. So that leaves Mr. Sung with your, well, that leaves Mr. Cheek with the motion to sever and Mr. Sung's response. Mr. Cheek, care to present the motion to sever?
Yes, Your Honor. Since there has been motions for summary judgments now have been heard, and we've had a motion for reconsideration, there are three parties: Brandon Nugent Entertainment, and Greg James, who we have now reached a decision on because their liability has now been decided by the court as a matter of law. They are no longer intertwined with the facts of the case, and therefore severance is proper. The court has, as you know, great discretion in granting severance. It seems entirely proper that these people severance should be granted. Final judgment should be entered on the claims against them so that they can be removed from this case, and we can focus on the real case here, which is plaintiff versus the possessor of the premises going forward.
All right. If I grant this severance, is there any party left who is not the possessor of the premises?
That will be the only party left. 17 LLC will be the only party left, and they are the possessor of the premises. Everyone else has either been non-suited or is covered by the summary judgments.
Mr. Sung, I've read the response and the cases that you've presented, and while I think that is a proper recitation of the law regarding severances, does it apply when we've got final judgments that people want to make final?
And Mr. Sung is muted now.
Why is it doing that?
I don't know. I didn't hear what that was.
Yeah, my apologies, Your Honor. I was muted.
Oh, somebody said something, and I don't know who it was. But go ahead, Mr. Sung.
Yeah. Your Honor, severance should not be granted to the Nugent defendants and Greg James because, I mean, they don't meet the elements to sever. The facts are so, even though the summary judgments were granted, the facts are still intertwined, right? They're interwoven with the case. The premises liability claim against Wayne Gregory James is tied to that of one set, the possessor of the premises. The vicarious liability, alter ego claims against the Nugent defendants are also intricately tied to the liability and actions of one set. So we don't think it's proper for it to be severed, but it is up to the court's discretion.
If I sever, if I sever the Nugent defendants and Mr. James into what would then be a final cause of action, and by the way, Mr. Cheek, I'm not awarding contingent fees on appeal with a severance. I mean, unless you can show that there's a basis in this cause of action for attorney's fees, and I don't see one. This isn't a Chapter 38 case. If I sever them and the judgment becomes final, will that hamstring plaintiff in plaintiff's case against 17 LLC?
If in fact there is further evidence or discovery that those defendants are in fact liable, more liable.
Well, that would, okay. That would require evidence of their ownership or possession of the premises, not. Okay.
Yeah, and Your Honor, one more thing, and just as you pointed out about the contingent fees that are being requested by the defendants, I mean, we object. I mean,
I'm not granting the contingent fees, period. So, all right, I will sever the claims of plaintiff. Change that. That is not what I'm doing. I'm severing the claims from Ms. Scott and Ms. Rogers against 17 LLC into a new cause of action. The pending cause of action against Nugent Entertainment, and James will remain, and the judgments then will become final judgments. Mr. Cheek, I would like you to prepare an order to that effect. Because it is your client that has sought the severance, I'm going to order that the defendant tender the filing fee for the new cause of action. And the order is to provide that the cause number for the new action will be assigned by the court once the filing fee is paid.
Yes, Your Honor.
And then if you wish to submit a new final judgment, you're welcome to do that. Otherwise, the summary judgments will in and of themselves become final judgments. But I'm happy to consider a new final judgment incorporating the summary judgments that were interlocutory as to all three.
Yes, Your Honor.
Okay. Suggestion that you get that to me today.
We will revise the order that's on file based on your instructions and get it back to you today.
Very good. Anything further, counsel?
No, Your Honor.
No, Your Honor.
All right. We all have a happy new year, and with that, you are excused.
Thank you, Your Honor.
Thank you, Your Honor.
I expected more highlights there.
Yeah.
Should have read that section in that response.
Do you want me to turn YouTube off or leave it on?
What's that?
Do you want me to turn YouTube off or just leave it on?
Are we, oh, you can turn YouTube